Oh, yay, oh, yay, oh, yay. The Honorable Court of Appeals for the 11th District of Texas is now in session.
Thank you very much. Good afternoon, gentlemen. We appreciate you joining us today for this argument. Before I call the case, I have an administrative matter to discuss. And I will ordinarily, the judges would be on a bench side by side, and we could help each other out. So we may have to do an open discussion with that to make sure we cover it. But what we have discovered is that there is sealed records that are in they're referenced in the briefs. But those sealed records do not appear in the appellate record that's been filed with this court. Our clerk's office has checked with the trial court clerk, and the trial court clerk does not have these documents. Without knowing, I would venture this guess. Perhaps those documents were given to Judge Dar, and for some reason they didn't make it to the trial court's documents. And what I'm specifically referencing is a document that appears at page 4467 in the clerk's record. It's an Appendix A, and that's not something we have to hash out right now. I'm just laying this out there to see if we can, if an agreement is feasible to get these documents in. They're sealed records. That's an appendix that lists various exhibits that are associated with various motions. It's a 2-page document. And it may be something that the co-counsel can help with as you present your arguments. I'm just presenting that we do have a dilemma. We don't have those documents in the appellate record. And so I'm open to suggestions on how to handle it. If you could come to an agreement what they are and have them submitted, filed in the trial court and submitted to us as a supplemental record, that'd be great. That'd be the easiest way. But it may be something that's not feasible to do. It might be a situation where if an agreement can't be reached, we just have to send the matter back for the trial court for the limited purpose to see if that record can be established. So I'm just laying out the problem and hopeful we can come to a solution for that or find a solution for that.
Well, Judge Bailey, Stephen Crane for Apache. I'm
yes.
confident that we can sort this out. I can't imagine that there's a document. I see Judge Arnott nodding.
Yes.
The parties who work cooperatively on the record, and I can't imagine us not getting to a point where you have that document.
Sure. And
I also don't think it's probably case dispositive, but then I don't know what the document is. So
Yes, I don't know either, but there was a lot of confusion in Midland between the reporter, sealed documents being given to the clerk and different clerks getting them. And we've had a lot of difficulty, but we can agree to clear that up. We'll get that to you.
Thank you very much. Appreciate it. So with that being said, we will proceed with our argument today. This time the court would call for submission cause number 11-19-183 CV, Apollo Exploration et al. Versus Apache Corporation. Mr. Arnott, are you ready to proceed?
I am, Your Honor. If I may, before I begin my argument, I'd just like to take a brief moment to express what a privilege it is to be here in the 11th Court of Appeals. I was licensed practice law 45 years ago, and I took my lawyer's oath in this court for Chief Justice McLeod. My first oral argument was made here. Later, I took my oath as a judicial officer. I have taken every subsequent judicial oath and every oath as a statewide commissioner before this court. And I just wanted to say I may not have another opportunity to address this court as an appellate advocate. I'd hoped I could be there in person, but technology's come a long way, because I remember when the court did not even have computers. So if it's only virtual, it's an honor to appear in this courtroom. Now, may it please the court.
Yes, sir.
Mr. Crane, the appellants bring a contract case with a large number of documents involving the usual contracts in the oil and gas industry. Oil and gas lease, a memorandum of lease, amendments to the lease, a purchase sales agreement, and the company joint operating agreements. The final judgment in this case is based upon a no evidence summary judgment holding that appellants did not even provide a scintilla of evidence of damages. That final judgment rests on 4 motions to exclude expert, which in turn rests on 6 judgments for partial summary judgment. This judgment on appeal is like a 3-legged stool. If the trial court erred on any of these rulings, the stool cannot support itself. The judgment cannot stand, and this judgment must be reversed and remanded. And I would like to take this opportunity to thank the court for the granting additional words, and I apologize for the length of the brief, but we had to file this voluminous brief to ensure we had preserved every error. And may I first begin by giving the court of an overview, hopefully that I may reach in my allotted time. First, the trial court.
And sir,
Yes.
knowing that you have limited time to present your arguments to the court, can you prioritize the issues that you believe the court should consider and that you believe would justify a remand?
Yes, Your Honor, I can, and I will do that. As I address each issue, I will lead off with that. So first, the trial court struck the testimony of D. Patterson, a damage expert. Every complaint made by Apache went to the weight and not the admissibility of Mr. Patterson's expert opinion. Next, the trial court struck the testimony of Peter Huddleston, the damage expert, without any basis in law and with no explanation. Apache's motion attacked Huddleston for not amending his expert report to conform to Apache's theory of damage. Huddleston refused to swear to a version of facts dictated by Apache, which he knew to be untrue, and the court struck him. Third, interrelated to the order striking Patterson and Huddleston are a series of contract constructions made by the trial court as a matter of law. Each of these orders were an attempt by Apache to limit its damages and splinter Apache's ability to orderly present this case to the jury and receive a fair trial.
It's my understanding that on the eve of trial, Apache requested the opportunity to file a no evidence motion on damages with the hope that if it were granted, the previous rulings could be merged into a final judgment.
Yes.
Is it your understanding that the basis for Huddleston's exclusion was that subsequent opinions to be expressed by that person were not timely disclosed?
No, not at all. With regard to Mr. Huddleston, we have to go into the length and depth of his value termination based upon the oil and gas lease.
But
So
wasn't
let
that the trial court's ruling that it was an untimely disclosure of supplemental opinions by Huddleston?
No, I don't believe so, Your Honor. I don't believe that was not why she struck it. First of all, if the court reviews closely Apache's motion to exclude the testimony of Peter Huddleston, the court will notice in that motion, Apache did not cite one rule, one statute, one case for its proposition. And the trial court merely granted the motion with no explanation. And when a trial court acts in an arbitrary or unreasonable manner without any reference to any guiding principle or rules, that very definition is the definition of abuse of discretion. And that act, Justice Trotter, alone is sufficient to reverse this order without addressing Apache's argument. Now, with regard to, I believe that it's treated in much more detail in our brief. And I'll have to rely on that because I see I'm already running out of time. But with regard to Huddleston, the trial court struck his because of they believed that his testimony, which was insufficient to on the facts about his opinion. He used he did. He used the discounted cash flow methodology. And Apache never attacked his credentials. They never attacked his methodology. All they did was give a series of attacks that were only on questions of fact and go to the weight of the evidence, not the admissibility of the evidence. Let me quickly back on to, if I can, Justice Trotter, on this oil and gas lease. It is not complicated, but it is confusing. And it just takes getting down, laying all the documents out, and tracing the train of title. The Bivens lease had a 3-year primary term, January 1st, 2007. That's all of 7, all of 8, all of 9. After the expiration of the primary term, the leases had 1 calendar year to satisfy a drilling commitment. The lease expressly referenced the memorandum. The memorandum of lease expressly referenced the lease, and it is well settled that a purchaser is bound by every recital, reference, and reservation contained in or fairly disclosed by an instrument which forms an essential link in the chain of title to which he claims. The memorandum of lease expressly states the primary term expires on 12/31/2009. The trial court refused to consider the memorandum, holding that primary term expired January 1st of 2016. The primary term had elapsed even before Apache first took title. The lease is only perpetuated on the continuous drilling clause. The lease and memorandum and continuous drilling clause were amended 5 amendments. They were amended 5 times, and each one of them refers to the lease, the memorandum, and all previous amendments, and expressly states that it ends on December 31st of that year. It is seamless. They are all stitched together. Under the unambiguous terms of the PSA, Apache owed appellants notice in November of 2014 of their intention to let the North Block expire. They even filed a release of public record stating that the North Block expired on 12/31/2015. Striking Huddleston's testimony as to the expiration date of the North Block was error. His expert opinion, some evidence of damages, and there's no final judgment must be. Without his, and you ask this question, Justice Trotter, without his opinion, then that three-legged stool cannot be supported, and it must be reversed and remanded. Now, in my remaining time, if I can, I would like to briefly touch on the trial court's erroneous construction of the contracts as a matter of law. Appellants wanted to protect themselves in the event that Apache was not interested in developing any part of the prospect, and Section 4.1 clearly states that intent. Gun Oil had been originally working interest owner with appellants. They executed a separate PSA, as all of the appellants did. Later, Gun sold his remaining interest to Apache. The trial court held that Apache need only to offer each appellant the proportionate share of working interest that each independent appellant conveyed to Apache. Regardless of their procedural shortcomings of their motion, this interpretation completely eviscerates the parties' agreement under their JOA, the area of mutual interest, the terms of after acquired interest, and the definition of expenses as well as others in the JOA. They are all interrelated. Section 4.1 states that Apache has to offer all of Apache's interest in the affected leases to appellant. If Apache was going to lose or release one or more, the trial court construed all of Apache's interest to mean only Apache's interest it bought from the appellants, and not the after-acquired interest it bought from Gunn. But all means all, and every term in a contract is presumed to have an effect. Next, the trial court construed that effective leases, and that's leases with a capital L, to mean such leases using a small letter L. Lease with a capital L is a defined term, and courts may not replace one term in a contract with a different term from someplace else. The term affected leases with a capital L was negotiated to provide and allow appellants to perpetuate all the leases. For example, if an expiring lease only covered 10% of the undivided mineral interest within a geographical boundary, it would be impossible to perpetuate that lease with one drilling rig without title to the remaining 90% of the undivided mineral interest. And therefore, they're included in the affected leases with a capital L. The word affected was inserted by Apache, and they struck through such leases with a small L. That's just the opposite of what they're trying to do here. And the courts must construe contracts in their entirety so that no part will be rendered meaningless. The trial court rewrote Section 2.5 by completely rewriting another defined term. 2.5 gave the appellants the option to back in for an additional 1/3 interest, and this was conveyed, and this is what's known as the back-end trigger, and it was defined as when expenses reach 200% of project payout. Project payout is a defined term. It is defined as the first day when specified revenues are equal to specified expenses. The court construed this to mean 200% of Apache's expenses. Now, the easiest way to understand this is just by using numbers. In 2013, Apache showed that the project payout balance was 0, and the appellants had backed in. But by the end of that December, they produced a balance of 200% of Apache's expenses. It was over $177 million, and it didn't do anything but go up from there. So the court may not rewrite the parties' contract. Further, Apache's motion, which was granted in all particulars, says the project payout includes all costs, not just the cost approved by appellants. Not so. Appellants merely urge there are fact issues as to which expenses are to be included in specified expenses. The ruling on 2.5, courts does a lot more than just redefine back-end trigger. It effectively rewrote the defined terms of operating costs in the JOA and costs assessed hereafter, meaning incurred cost. It negates JOA Article 4D as well as other JOA provisions. And so I would just say the trial court erred in its construction of the lease, the memorandum and amendments, the continuous drilling clause by holding the primary term expired on any date other than the express language of the contract. The trial court erred by not construing all to mean all, by removing the word affected from a defined term, and by redefining specified expenses, a defined term in the contract, to being Apache's chosen expenses in Section 2.5. So these orders should be reversed. Now, Justice Trotter, all of these are so intertwined that any one of them could cause, in my opinion, these are summary judgments. There are fact issues everywhere, could cause a remand. But because they are intertwined, we would like the court to review each and every one of them. So I know that's not the most judicial economic way to do it, but I'm going to reserve the rest of my time for my rebuttal. I would ask the court to refer to our brief because there's so much depth I could not go into, and we think it's well briefed. So with that, I will turn off my microphone and turn the stage over to my esteemed colleague, Mr. Crane.
There is certainly a lot to consider, and I think last reading, our count was the appellate record was almost 14,000 pages, so we'll do our best to get through every one of the documents that has been filed.
Yes, there's 14,000 pages and we're asking for more. So there you go. Anyway, thank you, Mr. Arnott. Mr. Crane, are you ready to proceed?
I am, Your Honor. Thank you. Good afternoon, and may it please the court. I'm Stephen Crane. I represent Apache, and there is a big record here. I have a plan over the course of about 17 and a half minutes, I think, to try to walk through the key events in the case and to try to put this in context. I will touch on the things that Judge Arnott spoke about, and I'm mindful of Justice Trotter's suggestion to focus on those things that we believe are the most important for the court to look at. So here's my plan, subject to the court's plan. First, I'm going to talk about the end of the case, when the trial court struck appellants experts for the final time. Then I will turn to the start of the case and walk through several of the motions before you, starting with the exclusion of D. Patterson and an associated summary judgment. Next, I will talk about their substitute expert, Pete Huddleston, and two more summary judgments that followed his disclosure. Finally, I'll come back to the end of the case and wrap it all up. So I begin at the end, Your Honors. On March 20th, 2019, 12 days before trial, appellants disclosed the damages that they were going to seek. Appellants were late in their disclosures. It was less than 30 days before trial, but that was hardly the beginning of their problems. Appellants disclosed a damage model and corresponding expert witnesses that did not comply with orders issued by the trial court over the course of 2 years, which had narrowed appellants' recoverable damages. When appellants disclosed,
Mr. Crane, when
Yes, sir.
when these, I guess, for a better way of characterizing supplemental opinions for Mr. Huddleston were presented, you had his original opinions, and I would assume on the eve of trial counsel was prepared to present a blistering cross-examination to Mr. Huddleston. So when these supplemental opinions were presented, you had Mr. Huddleston's underlying methodology and the data that he relied on to express his opinions, correct?
Not quite, Justice Trotter, not quite. When Mr. Huddleston issued his initial report, I'll skip ahead a little bit. I appreciate this. When he issued his initial report, he did a fair market value analysis. He did an analysis that D. Patterson said was impossible to do, but he did it. But he included in his analysis damages for the gun interest, which the court ruled subsequently they were not entitled to. And he included damages for based on the North Block expiring in 2015 as opposed to 2016, which I'll hope to be able to get to. By the time we get to trial, now we were asking in months ahead of trial, send us your new disclosures, because we knew the court had ruled on this, but we didn't have a new damage model. And changing these numbers, it's not simple arithmetic. It's complicated because of the various years involved, the gun interest, and the status of certain leases. So it's not simple math. So we were asking for an additional disclosure.
So is it your position that what was disclosed essentially 2 weeks before trial constituted new opinions rather than essentially a refinement of the original opinions that Mr. Huddleston had presented?
without question, because in their trial designation, 10 days before trial, 12 days before trial, they designated Huddleston as an alternative expert. They have 3 damages expert. They excluded Patterson, a brand new expert, Graves, and then Huddleston as an alternative. But for Huddleston, there was a new aspect of his opinion, which was that his values were going to be applied to acreage that D. Patterson had claimed the plaintiffs were entitled to, that had been overruled by the trial judge. The case, so when we got to trial, appellants disclosed experts that either been previously struck or were brand new, or that relied on models, and that goes to Huddleston, in flagrant contravention of the court's orders. And so the court was well within her discretion in striking the experts. The case has a long history, but it ends with appellant's election to put forth legally deficient expert witnesses to talk about damages that were foreclosed by prior orders. The components of the components, I'm going to try to catch up. The components of appellant's damage claims need to be put into context, because in turn, they put into context the trial court's various orders. Appellants claim that on November 1st of each year, Apache was required, if it did not have plans to drill or otherwise keep a lease, to offer that lease back to appellants. To be clear, appellants had no obligation to accept the leases back, and in fact, did not take leases back when offered. Still, the claim is that Apache was obligated to offer leases back on an annual basis. Appellant's damage model has 3 components based on that premise. First, the year in which they claim the leases should have been offered back, so that leases expired in 2013 should have been offered in November 2012, according to them, and so on. Second, the number of acres in the leases that should have been offered back. This sounds easy, but it was made complicated by an expansive interpretation of the term affected leases. Judge Arnett spoke about it. I'll get to it. Invented by appellants for the first time during litigation. Third, the value of the acreage on the measuring date, November 1st of 2011, 12, and so on. Appellants changing positions and tactics on the claimed value of the acreage created significant work for the trial court. So back to the March 20 disclosures right before trial. For the years 11, 12, and 13, appellants disclosed damages claimed by D. Patterson, who had been struck by the court after a Daubert hearing 20 months earlier. At trial, Patterson had not changed his model, not one iota, and still valued the acreage far beyond anything indicated by the market. Patterson also still applied his values to leases and acreage far in excess of leases that expired in the following year, a tactic foreclosed by another summary judgment. Patterson, already struck by the court, was redesignated without any adjustment to his methodology or any adjustment to the numbers of acres to which he applied his wildly out-of-market numbers. Appellants also claimed damages for leases that they said should have been offered in 2014 and 2015. For those 2 years, appellants identified Dean Graves, who had not previously opined on damages. His designation, 12 days before trial, was too late as a matter of law. Even if he had been properly designated, Graves had not, as he candidly acknowledged, attempted to determine fair market value. In fact, he came up with values even more outrageous than those of Patterson, prices that have never existed in real life in Texas. Finally, as an alternative to Patterson Graves, appellants offered up Pete Huddleston, who had done a traditional comparable sales analysis when Patterson was originally struck. But there were a few catches. First, at the time of trial, Huddleston had not adjusted his model in accordance with additional summary judgments issued by the court. Second, and this was new, Huddleston's per acre values, like those of Patterson and Graves, were to be applied to acreage that the trial court had long ruled was not recoverable in the affected leases summary judgment rule. Appellants could have attempted to put forth competent damage models that may have suggested damages in the millions of dollars, but appellants were shooting for a $1 billion recovery. Confronted with appellants' arrogant disregard for her rulings and Texas disclosure rules, The trial court acted well within her discretion in excluding all of appellant's damages experts. Appellants gave her no choice. This case is about the value of oil and gas interests, and Texas law requires expert testimony to value those interests. At trial, appellants had no competent damages evidence despite Judge Starr's generosity in granting continuances to give them multiple chances. They made their choices, and the trial court refereed the case patiently, correctly, and ruled within her discretion. With that context, let me go to closer to the beginning and the exclusion of D. Patterson. In late 2016, Patterson proffered a nearly $1 billion damage model. There are a couple of points for context for the court. In 2011, Apache paid appellants $14.5 million for about 75% of their interest. That works out to about $338 an acre. In September 2011, appellants sold substantially all of the rest of their interest in the same acreage for $1,200. Patterson claimed that by November 1st, 2011, a few months later, Apache owed appellants damages of $528,355,000 for the fair market value of just some of the leases. It sounds like I'm making this up. Sold for $14.5 million in March, damages of $528 million in November. How? How did Patterson claim that values went from $338 to $6,000 an acre in just a few months? That was the first issue the trial court had to address. It didn't pass the smell test, and more germane for this court's work, it did not pass the Robinson-Daubert test. Here's what Patterson did. First, he said there were no comparable sales, so that he could not do a comparable sales analysis, the gold standard when valuing acreage and mineral interest. Again, a few months earlier, the same acreage sold for $338. Patterson, in his words, ignored these sales. Patterson, second, used what turned out to be a wildly optimistic projection from a 2014 Apache investor presentation to create what he called discounted cash flow values in 11, 12, and 13. That 2014 information, even if it wasn't conjecture, was impossible to have been known in 2011 or 2012 under a willing buyer, willing seller test. That is absolutely prohibited, and Patterson's testimony cannot be clear on this. He just flat admits that he uses 2014 data to value 2011, 2012, 2013 interests. Third, while the 2011 transaction between Apache and appellants was based on a conventional vertical play in the Canyon Wash Formation, Patterson valued it as if it was an unconventional horizontal shale play in a different formation, the Canyon Lime. No one ever thought the Wash was an unconventional play, and it never was. When cross-examined, Patterson gave up the ghost on this as well, conceding that the Wash did not have all of the required features to be considered an unconventional play. The trial court acted properly and well within her discretion in excluding Patterson. There was another aspect of Patterson's model that the trial court was forced to deal with because it was a new position taken by appellants. When Patterson issued his report and valued leases that he claimed should have been offered in 2011, he did not value just the leases that expired in 2012, but a much bigger group of leases, including leases covering more than 100,000 acres that Apache was in fact drilling on and keeping under lease. The contract says that when Apache contemplates losing one or more lease in the coming year, then, quote, purchaser shall concurrently offer all of its interest in the affected lease to sellers. Appellants and Patterson claim that that term, affected, refers not to the leases that Apache did not plan to retain, but to some other amorphous group of leases, including leases being held by Apache, such that if Apache is going to let this 1 acre lease go, but it's spending millions of dollars drilling on this lease adjacent, their position is Apache was required to give back both of those leases. Apache moved for summary judgment. Both parties took the position that the language was unambiguous, and the court ruled that only leases that were in fact going to be lost in the coming year were affected leases. It's logical. That's the affected lease summary judgment. Turning now to Huddleston. Patterson was struck and appellants asked for a continuance, saying that they knew that they accepted the court's ruling on Patterson but needed more time. The judge gave them, Judge Starr gave them more time. Appellants designated Pete Huddleston. Huddleston does what Patterson says couldn't be done, which is a traditional comparable sales fair market analysis. His values hover around $1,500 until 2016 when the oil price dropped and it drops to $200. There's 1 year, 2014, where Huddleston's values are about $6,000 an acre. The problem appellants had was no acreage expired in 2015. Therefore, there was no acreage to value in 2014, but Huddleston changed that. A large section of a lease, the North Block of the Bivens Ranch lease, measuring about 30,000 acres, expired at midnight on January 1st, 2016. But Huddleston did not value the North Block at $200 an acre. Instead, he valued it in 2015. Instead, he claimed it expired in 2015, so he could value it in 2014. That changed the value using his numbers from $5.8 million to $187 million.
Isn't there a significant difference in damage calculations depending on what is the correct lease expiration date?
There is.
Between December 31st and January 1st.
A stitch in time, indeed. And that absolutely, you're absolutely right, Justice Trotter. And it's because of the way the oil market, there was excitement in the area. Prices drove up for a very brief period of time. That's in 2014. Then there's a crash in the commodity price, and it drops from according to Huddleston, from $6,500 to down to $200. But yes, it is a significant difference. And let me talk about, because this is the North Block, and I'll sort of go off script for a second to stay with you, Justice Trotter, appropriately, I should say. So this is the North Block summary judgment. So we get Huddleston's model, and he's changed the North Block expiration date by a day so that he can measure it in 2014. Nobody had ever taken this position before. Plaintiffs had never, in 10 ways from Sunday, the plaintiffs had always said it expired in 2016, but now they're going to do it in 2015 so they can measure it in 2014 and get to that $187 million damage model. Here's the deal, and what y'all will be confronted with. Texas law says the lease, Texas law says that the lease controls here. And the very first sentence of the lease says, this agreement is effective the first day of January 2007, from which date the anniversary date of the lease shall be computed. That's the answer in Texas.
Wasn't there a recorded lease to the effect that the North Block lease was effective December 31st of 2015?
So what happened was, in August of 2016, Justice Trotter, the lease, let me go back in time. The lease requires that if any part of it expires, you have to file a release of record. So the first step is the lease expires. Second of all, the Apache has to file a release. So the lease expires on January 1st, 2016 at midnight. And Apache in August of 2016 files a release. And when it files the release, it makes it effective as of December 31st, 2015. But that doesn't change the terms of the lease. And look for our case on this directly on. There's a case directly on point on this issue in Texas, which is RIPI interest.
Was there other evidence submitted in response to your motion for summary judgment on the North Block lease that the lease did in fact expire on December 31st of 2015?
No, they relied upon they rely upon this release. And in fact, if you look at their brief says very specifically that we're relying upon this release, and it's not extrinsic evidence, which of course it is. The law, and I cited the wrong case, it's Holman versus Meridian Oil. A lease expires when it expires. If the release could have been dated 1885, it wouldn't make any difference, because the lease, the Texas law is that the four corners of the lease controls. And the fact that Apache 6 months later, Apache does something after the lease expires, so it literally can't alter the actual expiration date, no matter how it's dated. I noticed that I have about a minute and a half. So I'm going to cut out a fair amount, but get to I'm gonna leave y'all to resolve the gun interest summary judgment on the pleadings, other than to say to you that all does mean all, and that Apache must offer back to each seller all of their interest, not more interest. That would be a forfeiture to Apache and a windfall. At the end of the day, appellants redesignated D. Patterson, claiming that there was a Railroad Commission filing in 2014 that made the wash part of the canyon line. It doesn't say what they say it says, and the Railroad Commission, in reviewing the application from Apache, it was a spacing application. The Railroad Commission says wash, lime, two different structures. The wash is a traditional vertical play, and the lime is a horizontal play. So that doesn't get them there. Then as to Dean Graves, who was designated at the very last second, he relies upon an Apache spreadsheet that discloses corporate write-downs. And the claim was that was brand new. First of all, it's not fair market value. And second of all, we showed to Judge Starr that they had received that same spreadsheet in 2017. On the last day of trial, the judge appropriately struck their experts who were not disclosed appropriately and whose methodologies were unsound. I'm out of time.
Thank you very much, Mr. Crane.
Thank you, sir.
Mr. Arnott, do you have a rebuttal?
Yes, Your Honor. I'm sorry. I had to find my microphone. Thank you. I'm going to rely on the record, but I don't remember, because I don't remember it the same way that Mr. Crane does. What I remember is the only new designation of an expert was for D. Patterson. Dean Graves, excuse me. Dean Graves, D. Patterson was for Dean Graves. And he was not called as an expert on damages. He was called as a CPA. Apache had produced a spreadsheet, and buried in that spreadsheet, let me see this. They had an innocuous entry, expired and abandoned leases, labeled NB. And there was, the first one was on row 7,863. The second one, 15,000 rows later. A total of 32 lease entries were made, scattered through 161,000 entries. Now, Apache objected that we should have caught that earlier. However, all that Dean Graves was saying is that Apache is the one that valued those leases at that value, and he was just testifying as somebody who could read a spreadsheet. Huddleston gave no new opinion. It was always disclosed before trial. And so it was only Graves. Now, there's going to be a lot of things we're going to quibble about. Let's just talk about, Apache only wants to talk about the lease and not the memorandum. The memorandum very clearly says it ends at December 31st of 2009. And it clearly says the primary term ends, excuse me. The lease refers to the memorandum refers to the lease. It wouldn't matter anybody's opinion. In construing a contract, you're going to look and see what the contract says, not what the parties thought it said. And it clearly says that it expired at the end of the year, on every calendar year on the amendments. Apache argues about their own presentation. They go ballistic over $1 billion, or I don't know, exaggeration, but that came from their public presentation off of their webpage when they were touting it, trying to raise money. I think our brief really covers well the difference in the value of the leases, the ones with production, when it was first done without afterwards. So I see that Sherry has pulled the clock out of the wall. Means it must be close to time to go, and she's tired of listening to me. Let me just close with this, if I may. Every oath I took as a lawyer and as a judge, I swore to uphold the laws of the state of Texas. That is a serious obligation. It is an abuse of discretion for a judge to consciously disregard the law of Texas. When the law is settled, well known, and called to the attention of the court may not disregard it. Further, a judge may not delegate its authority to be the sole judge of the law for an outside arbitrator. While this court may, the trial judge is the expert of the law. We have 16 orders and judgment in our prayer because they're all intertwined and because they're all erroneous, because they require appellants to piecemeal their case, and because they deprive appellants of a fair trial on the merits. We request that the court reverse all of the rulings, the orders, and final judgment, and remand the entire case to the trial court for a trial on the merits. Thank you.
Thank you very much. Gentlemen, your case has been submitted. Here in a minute, Ms. Williamson, I'm stalling till she gets back to her chair. She will recess us from court, but your case has been submitted. Thank you so much for your help in this very difficult case.
Thank you, Your Honor.
Thank you.
Thank you, gentlemen.
Oh, yay, oh, yay, oh, yay. The Honorable Court of Appeals for the 11th District of Texas is now adjourned.